Ready, start. This court, upon a perusal of the impugned orders and upon a perusal of the material brought on the record, finds that there is nothing to indicate that Gaon Sabha was divested of its rights or that the rights of the Gaon Sabha was resumed by any notification issued by the state government. Full stop. This court finds that there is nothing to indicate that a notification under section 117 within bracket 3 and 117 within bracket 6 had been issued declaring that the plot in question has been transferred to another local body. Full stop. Merely by extending the territorial limits would not divest or resume the proprietary rights of the Gaon Sabha unless there is a notification to that effect under section 117 of the UPZA and LR Act. Full stop. Consequently, the court is of the opinion that the Gaon Sabha continued to exercise its right and perform its functions. Full stop. The proceedings initiated under section 122-B of the Act was maintainable. Full stop. From the evidence brought on the record, it is clear that the plot in question was never used as a khalian and there is clear evidence that the Nagar Palika was paying rent since 1953 and that the shops were existing since then, and one of the shop which was being used as an octroi post. Full stop. Even though the contention of the petitioner is that he was in possession prior to the abolition of the Jamidari and that the land was deemed to be settled under section 9 of the Act, this court, however, does not find any evidence to that extent, but nonetheless, finds that the petitioner to be in possession since 1953, full stop. The court also finds that the permission was granted by the collector in 1967 to reconstruct the shop in question, full stop. Further, the Lekpal in his report has submitted that the land was shown as an abadi and an octroi post was shown on the plot in question in the consolidation map. Full stop. Consequently, the finding of the revisional authority that the land was not shown as an abadi in the consolidation map is patently perverse. Full stop. The statement of the Lekpal clearly indicates that the land was shown as an abadi in the consolidation map. Full stop. In the light of the aforesaid, the court finds that the eviction of the petitioner from the land in question is not proper. Full stop. A small portion of about 250 square yards, which is not reserved for an important public purposes like a pond or a rasta, in which some shops has been constructed since 1953, should not be demolished because the plot has now been identified by the authorities as a khalian. Full stop. In such a situation, reasonable damages would serve the public purpose. Full stop. The Gaon Sabha holds the land for the benefit of the public. Full stop. No useful purpose would be served if the Gaon Sabha evicts the petitioner and thereafter allots it to another person. Full stop. The Tehsildar imposed damages of rupees 42,500. Full stop. The court finds that the damages imposed by the Tehsildar has not been seriously challenged by the petitioner. Full stop.